Joining me now is law professor and former General Counsel to the U.S. House of Representatives, Stan Brand. Stan, thanks so much for joining me again.
My pleasure.
Let's summarize where we are right now. So as we know, last week, the Supreme Court heard oral arguments after Donald Trump challenged Colorado's December ruling that he would not appear on the state's 2024 primary ballot under the 14th Amendment. So before we dive into what we heard last week, can you once again explain for us what the 14th Amendment argument is?
Yes, it's a post-Civil War amendment as part of the 14th Amendment, which broadly enfranchised former slaves and provided for certain other rights for them. And then in lieu of the Civil War, the Congress passed a provision that said that anyone who had previously taken an oath to support the United States and who had engaged in insurrection or rebellion would be barred from serving in a enumerated series of positions. And then added yet another provision that said that Congress could remove that disability by a 2/3 vote.
So now let's flash forward to where we were last week. The Supreme Court, like I said earlier, heard oral arguments. What are your main takeaways from those arguments?
Well, it was a very intellectually challenging argument for people who were not into the nuances and details of this provision, which was made all the more difficult by the fact that there really is no Supreme Court or even appellate court constructions of this section. And so what I took away after 2 hours were a couple of key points. One is what I sensed, and I caveat this by saying you can never tell what's going to happen from the oral argument in terms of the ultimate decision, because judges use the oral argument to do several things. They use it to parry with each other. They use it to probe the consistency and positions of the advocates. And sometimes they telegraph and sometimes they don't. But what I got from it were a couple of key points. One is, I think there was across the ideological spectrum a suspicion that they shouldn't allow one state to determine a potential candidate's eligibility under the 14th Amendment, because for all practical purposes, a definitive ruling on the 14th Amendment by the court as to Colorado would bind every other state. And so there was this theme that kept coming out across the spectrum that this is a national question and it should be something that is uniformly applied. That was number one. And number two, they focused on a couple of issues. One was, who's an officer under the United States as defined in the 14th Amendment? And that's confusing because there are references to officers under the United States and officers of the United States in different provisions of the Constitution, including the Commissions Clause, the Appointments Clause, the Impeachment Clause, and how to mesh these and make them consistent and interpret the 14th Amendment in light of that is really quite an exercise. So that was one focus, is that. And then the other focus was that former President Trump wouldn't necessarily be adjudicated on whether he was eligible or not until he were actually elected, because it says holding office, not running for office. And the Trump lawyers fashioned a pretty interesting argument, and they said, well, because the 14th Amendment provides for Congress to waive the disability, it acts like the qualifications clause for members of Congress. That is, it's not ripe until he's elected and shows up on Inauguration Day. Now, of course, from a practical standpoint, that raises a series of questions about how that would play out if, in fact, he were elected and the Congress convened on January 6th to count the Electoral College vote, and there was dispute over whether he was entitled to be sworn in under the 14th Amendment. But those were the two takeaways that I had. And my guess is that they will take the path of least resistance to decide this case. One, because there's just a plethora of issues that are unresolved that they don't need to resolve to get an answer. And two, I think they want to project some degree of, if not unanimity, overwhelming consensus in the argument that they ultimately endorse. So that's what I think the takeaway was from a very exhausting 2 hours.